पहला जो वाक्य है, पहला लाइन है इस आदेश की, उसमें लिखा है इट्स अ सिग्निफिकेंट इशू, इट्स अ वेरी इंपॉर्टेंट इशू, एन इंपॉर्टेंट क्वेश्चन हैज बीन रेज्ड। दूसरा कि अब आप ही निर्णय करिए कि जो भ्रम फैलाया जा रहा है, जो ऑर्डर में लिखा है वो सही है। दूसरा कि हम समझते हैं कि सभी ग्राउंड्स आपके, सभी याचिकाएं, सभी आपके बिंदु खुले हैं। हम 28 को लगा रहे हैं, जब तक कुछ नहीं हुआ होगा। 28 तक चुनाव आयोग भी कुछ नहीं कर सकता, क्योंकि प्रक्रिया जारी है। 28 अब से 2 हफ्ते से कम है समय, या 2 हफ्ते है, 2 हफ्ते है। तीसरा, सभी हमारे दलीलें उसके बाद और उस दिन खुली हैं, किसी को बंद नहीं किया, निरस्त नहीं किया। चौथा, जो चुनाव आयोग का बड़ा स्पष्ट स्टैंड था कि आधार अपने आप में या किसी के साथ पर्याप्त नहीं है, उनका कि नहीं, ये 3 दस्तावेज आप कंसिडर करेंगे, वर्ड लिखा है कंसिडर। ये एक बहुत महत्वपूर्ण उपलब्धि है। कल अगर आप जाती हैं इन 3 दस्तावेजों के साथ, और मैं चुनाव आयोग में कहता हूं कि 3 दस्तावेज हैं, बहुत अच्छी बात है, आप घर जाइए, हमको वो चौथा वाला चाहिए, तो वो संभव नहीं है। ये नहीं है कि ये बाध्य है दस्तावेज आधार। अगर ये दिखा सके आप कि भाई आधार, कोई दिखा देगी ये आधार फर्जी है, फोर्ज्ड है, इस आदमी का हो ही नहीं सकता, इसका जन्म यहाँ दिखा रहे हैं 10 तारीख को, जन्म उसका कभी हुआ ही नहीं था, तब तो ठीक है, आधार नहीं चलेगा। लेकिन अगर वैसी चीज नहीं है तो आप ये नहीं कह सकते कि पर से आधार बाहर है, अपने आप में आधार बाहर है। और यही चीज लागू होगी आपके वोटर आइडेंटिटी कार्ड पे, यही चीज लागू होगी आपके राशन कार्ड पे। ये एक बहुत महत्वपूर्ण आगे अग्रणी पंक्ति की बात है। और इसके बाद सब दलीलों को सुना जाएगा और फिर रिकॉर्ड किया मेरा खुद का सबमिशन कि अगर अब से 28 तारीख तक की बात है ये, और 28 तारीख तक उनको सब सूचियों को देखना है, तो हम इस वक्त अपना आंतरिक, जो हमारे बहुत और सारे आदेश हैं, उनको प्रेस नहीं करते। ये मैंने रिकॉर्ड करवाया है, हमारे सब आंतरिक खुले। हम तो ये भी कहने वाले हैं कि इसको निरस्त करना चाहिए, इसको अधिकार क्षेत्र नहीं, कानून रूप से गलत है, लेकिन उसका सब समय आएगा 28 और अगस्त के बीच में, 28 जुलाई और अगस्त के बीच में। तो इसलिए मैं कहना चाहता हूं कि ये एक बहुत महत्वपूर्ण आंतरिक आदेश है। आंतरिक आदेश में मेन मामला लंबित है, सब जुडिस है, इस पर गलत अटकलें लगाना सही नहीं है, और मेरा उद्देश्य सिर्फ ये है कि इसको सही संदर्भ में आपके समक्ष रखना। एंड सेक्शन 23(4) was added in the Representation of People's Act, the Bible and the Gita and the Quran of the Election Commission, to say that Aadhaar is a valid card. And now this Dastavez undoes or violates a statute. It says it's optional. It says it may be there, may not be there. I will look at the other citizenship thing. So also astonishingly for the EC's own card. Election Commission, all of us have it, a EC voter card. This is known as the EPIC. That is to be ignored or not weighty enough to be taken into consideration. Ration card. So we said that these 3, and the interim order records that these 3 shall be considered, quote unquote considered. I'll tell you the impact of that in a moment. We then, and therefore I said that you amended the law to embrace Aadhaar and then kicked it out from the main bazaar. This is like applying Kafka in Patna, in Bihar. In 12 years, billions are linked, and yet Aadhaar is not good enough for a voter sync. वोटर सिंक के लिए आधार गुड इनफ नहीं है, बिलियंस को लिंक कर दिया आपने. Then I also pointed out in the court the sheer logistics, assuming there is some power. We are not assuming power, we are not conceding power, we are saying it's all unconstitutional, lack of power. But look at the logistics of it. A blind person knows that in July and August the sowing season draws large amounts of migrant labor from Bihar to Punjab, Haryana and other northern states. All of us know that in the very near future we have this curse in that area, especially North Bihar, of floods. Ordinary people, and remember we are talking maximum always hurt in such disenfranchisement policies are the poor, the marginalized, the minorities, those who are not backward but the backwardest of the backward. They, if they go back after a flood, cannot recognize where their house stood. That is the truth about Bihar floods. They are going to run like mad people in July and August, searching for Aadhaar cards, for this citizenship birth certificate, for father's certificate, for mother's certificate. And if out of 4.9 post 2003 persons, if you disenfranchise 2 crores on this basis, 1 crore on this basis, you are fundamentally affecting a unalterable, unamendable, sacred constitutional principle, basic structure. A level playing field is the heart of India's elections. An election is the heart of democracy. Democracy is the heart of basic structure. If a constitutional amendment violates LPF, level playing field, or elections, or one person, one vote, or democracy, then a constitutional amendment will be held to be unconstitutional on the ground that it violates the basic structure. Another point, there are many points, I'll not trouble you with, I'll end by saying another point we raised is very interesting, that you had 10 elections since 2003 in Bihar. 10. 5 Assembly, 5 Lok Sabha. In 2003, when you had the revision, there were 2 years left for Assembly, which happened in 2005. 1 year, 12 months left for Lok Sabha, which happened in 2004. Here you are having 1 month and now 2.5, 3 months. And if 10 elections could be held, why could you not have this particular revision after these elections? Why link desperately in a squeezed in period of 2 months this election and this revision? We also said that a very detailed revision, which is called summary revision, happened for 3 months last year. Last year in Bihar, 2024. That led to a notification by law of the electoral roll in January 2025, which is the valid electoral roll under the law of Parliament. There is no change to it. That valid electoral roll of 2025 in January for Bihar was commented upon by the EC in press notes of April, May and June. Not a mention that that was so defective, that was so horrible that we have to do a new one now, within 6 months. And yet in the end of June last week, suddenly they sprung this particular new scheme on an unsuspecting public. So friends, lastly, what is this order? Which is the only reason I am here in a press conference, to clarify and prevent all the misinformation, all the disinformation, all the mithya prachar going on. First and foremost, the court gives the shortest possible date, roughly 2 weeks away. Number 2, nothing can be done by EC or anybody else till those 2 weeks because the exercise is ongoing. That is why the court gives that date. Number 3, it specifically directs consideration. The word is to consider 3 documents which I have listed before you: Aadhaar, EPIC and ration. Fourthly, the EC therefore cannot per se reject these proofs. It cannot insist on a unilateral, unifocal proof only of the kind which the document of the press note says. Fifth, in the light of this, I was the lead counsel, that we need not press our interim stay, which is much more wider. We are saying stay the whole thing. We are saying don't have it's unconstitutional. But nothing is happening till 28th except a formal enrollment. Therefore, the matter will be argued then. So we do not need to press in this time, which is why I was not pressed. And all this, therefore, is going to be decided either on 28th or on short dates after that. Leaving all those points open, without limiting us in any manner, there is a clear directive to the EC on these 3 pieces and places of information. The coverage of Aadhaar is much wider. Even passports are 2% of Bihar. Aadhaar is much more. Between Aadhaar, EPIC and ration, it is probably 90% coverage. Therefore, there is a huge public interest advance by this interim order. Let us not misrepresent it, let us not distort it, let us not create a controversy where there is no scope for controversy. Of course, we can win, we can lose. That is to be done on 28th, but there is an interim order which has this scope and relevance. Thank you so much.